Welcome, I am the Loud Little Ducky. We are going to go over something a little bit different today in regards to Owens. Since we have found out for sure that the Chase J. Jones is tracked back to at least her phone number, and with further investigation, it could be more than likely tied back to her altogether. We've had our suspicions, whether it was through the language of, for me, it was the language in the quash of the subpoenas, as well as Medium articles and so forth, and just trying to get Clayton canceled. But does this put Owens more in line for criminal court with everything else that she's already done? So I want to look at the laws in Arizona, because that is where she is, and in California, where Chase J. Jones filed his motion to quash the subpoena in the Dave Neal lawsuit that Owens had on Neal. So we're going to break down Arizona and California and see what does she fit these different laws, and what are her possible penalties if she is brought up on criminal charges for the things that she has done in the Owens v. Eckerd case. So let's jump right in. So first, I want to go over some terms. That way, when we're reading these things, we kind of know what they mean. A written instrument is used a lot. So a written instrument is any paper, document, or other instrument that contains written or printed matter or its equivalent. B, any token, stamp, seal, badge, trademark, graphical image, access device, or other evidence of symbol of value, right, privilege, or identification. So we're mainly focusing, for Owens, we would be focusing on A, paper, documents, and things like that, written, printed matters. Okay, so a complete written instrument means a written instrument that purports to be genuine and fully drawn with respect to every essential feature. So when you are filing something in a court, it is assumed that this document purports to be genuine with every aspect and feature of that document. Because we are talking about somebody who doesn't exist, was able to go into a court or file online a document from an imaginary person. An invisible ghost filed a court document. It's not only a false document, but it is a false, fake person. And how does this happen? Is it because you're not required to give ID? Because if you're filing it online or submitting it online through a, I think he was pro per, Chase J. Jones. But why are people that aren't real, how are they able to file these documents? That shouldn't be able to happen. So 4, entity identifying information includes, if the entity is a person other than a human being, any written document or electronic data that does or purports to provide information concerning the entity's name, address, telephone number, employer identification number, account number, or electronic serial number, the identifying number of the entity's depository account, or any of the information or data that is unique to, assigned to, or belongs to the entity that is intended to be used to access services, funds, or benefits of any kind that the entity owns or to which the entity is entitled. So this has to do with like IDs and credit cards and things like that. Then we have 5, falsely alters a written instrument, which a written instrument, remember, is any paper document that contains written or printed matter. So falsely alters a written instrument, falsely alters documents, which we know Owens has done many a times in each of these cases. It means to change a complete or incomplete written instrument without the permission of anyone entitled to grant it by means of counterfeiting, washing, erasure, obliteration, deletion, insertion of new matter, such as inserting new things on an ultrasound, connecting together different parts of the whole of more than one genuine instrument, or transposition of matter or any other matter so that the altered instrument falsely appears or purports to be in all respects an authentic creation of its ostensible maker or authorized by him. So, altering creations to make them appear authentic, like an authentic sonogram, authentic medical records. That is falsely altering a written instrument. Number 6, falsely completes a written instrument. Means to transform an incomplete written instrument into a complete one by adding, inserting, or changing matter without the permission of anyone entitled to grant it, so that the complete written instrument falsely appears or purports to be in all respects an authentic creation of its ostensible maker or authorized by him. So the only person that could have given permission for these things to be altered would be the hospital where these fake medical records came from, wherever these sonograms came from, the person who owns those things or made those things, the originals, are the only ones that can give permission to do this. And we know the hospitals didn't give permission. We know many of the people who Owens has stole ultrasounds and stories and everything else from have not given permission. And even if they had, it's still not okay to submit them as authentic creations. 7, falsely makes a written instrument. Means to make or draw a complete or incomplete written instrument that purports to be an authentic creation of its ostensible maker. But that is not either because the ostensible maker is fictitious or because, if real, the ostensible maker did not authorize the making or drawing of the written instrument. Also, like altering the HCG tests, not okay. That one, the altered one was not entered into court. She just made it. She just sent it out to the media. But to create a fake doctor's note, to make it look like an authentic creation, to make these things look real, like you made, like creating a diploma that you didn't actually get. It's a fake diploma. It's a fake certification. It's a fake medical record. To create these things, whether you created it from scratch or you took things from places and then made it into something yourself, that is falsely making a written instrument. 8, forged instrument means a written instrument that has been falsely made, completed, or altered, which we've seen a lot of forgery. If you're fraudulently forging doctors' names on things, or nurse practitioners, or whoever's names. That is a forging instrument. Okay, so now we have our terms. So hopefully more of this stuff is going to make sense. First, we are going to go over Arizona, where Owens lived. Is she going to be wanted for false impersonation? Because this is what we're going to go over. False impersonation laws in Arizona. So it says, what criminal acts falls under ARS 13-2002? According to ARS 13-2002, any of the following actions are considered to be criminal impersonation in Arizona. So let's see if she has committed these criminal acts. Number 1, assuming a false identity with the intent to defraud another, or, well, allegedly. Remember, everything I say here is alleged. Nothing has been proven in court. She has not been charged. This is just going over the possibility. Could her actions land her under these criminal acts? That's all we're looking at. But if she has assumed the identity of a Chase J. Jones with the intent to defraud, she, under ARS 13-2002, has criminally impersonated somebody. 2, pretending to be a representative of some person or organization with the intent to defraud. Now, this one she hasn't really done. All she said was Chase J. Jones went to Howard University. So, I mean, I don't know that she would be... I don't think Howard University is going to like that very much. But she's not pretending to be a representation or head of something. She's just pretending to be just a plain Jane college graduate. Plain Jane. 3, pretending to be or assuming a false identity of an employee or representation of some person or organization with the intent to induce another person to provide or allow access to property. This paragraph does not apply to peace officers in the performance of their duties. Okay. So, to me, the only one that might apply is going to be this first one right here. Assuming the false identity with the intent to defraud another. She was intending to defraud the court, intending to defraud Dave Neal, and intending to defraud Clayton Eckert. Okay, in this next paragraph, whether it's due to technological advances that make committing criminal impersonations a breeze or the lack of violence needed, criminal impersonation is one of the most commonly committed crimes in Arizona. And I mean, with Adobe and AI and all this stuff, it is really easy to do that. But just because you can do something doesn't mean that you should, or that it's legal. I don't care for whose benefit. You should not do these things. It says, even though this crime appears to be minor, it is, in fact, a felony offense. Oh, it's no big deal to just pretend to be somebody. No, it is. Why Laura hasn't gone out and like stolen somebody's technical identity. She didn't steal their credit cards and assume their life and things like that, which can ruin people's lives. I mean, I cannot remember. I'm gonna have to think. There is a movie about a case where this person had to fight like hell to get anybody to believe that she was the real person and that she wasn't the one committing these crimes, and the fraudster was the fraudster and she was the real person. And like, they took over everything from this person. It's crazy. So while hers might be on a minor scale, it can be in fact a felony offense. In Arizona, criminal impersonation is defined according to ARS 13/2006, and if you are convicted, you will be charged with a Class 6 felony, and you will be fined if you have been arrested for criminal impersonation in Arizona. You face serious felony charges if convicted. And then, of course, says due to the seriousness of the charges you're facing, you can speak with a criminal defense attorney. Because I did get this part off of a attorney's website. Okay, so the movie that I was talking about is called Identity Theft: The Michelle Brown Story. You may be able to find it on YouTube. You may be able to, if you have Roku, those are the only places I'm seeing it for free. But yeah, the story of Michelle Brown. So if you don't want to watch the movie, you can look up the Michelle Brown identity theft case. We're not on that level with Owens. But that one is a crazy thing, and that's why it is very serious. Why it may seem to be not that big of a deal, it's crazy. All right, so the penalties for the crime are criminal impersonation in Arizona. Criminal impersonation is either a Class 6 felony or a Class 1 misdemeanor. Depending on the circumstances in Arizona, Class 6 felonies can carry a penalty of up to a year and a half in jail, and a Class 1 misdemeanor carries a penalty of up to 6 months in jail, in addition to facing jail time. If you are convicted of criminal impersonation, you may also be required to pay restitution to the victims as well as a fine. While jail time, restitution, and fines are serious penalties, being convicted of a felony also impacts your livelihood. Many employers avoid hiring individuals with a criminal record, and property owners may even deny your applications to rent from them. I don't know how banks feel about it either if you're going for mortgages or loans and things like that, but yeah, it can be a big deal. Now, since this would be possibly her first actual time of being charged, if she was to get charged with these things, they may waive jail time, give her some probation, whatever, but she would still have, she would probably sign a settlement agreement or something like that. But these are just the things that could happen. Again, none of this is real right now, but could it become a reality with Owen's behavior so far, and if she continues this behavior? Next, we are going to look at the California laws on false impersonation. And if you want to call it catfishing, you can call it catfishing, because that's kind of what she did with Chase J. Jones. Deceptive activity, creating a fictional persona and victimizing people, which she does. So, in California, we have 529. I believe it's Penal Code 529. Yes, Penal Code 529. Not the dirty mind thing. People, keep your minds out of the gutter. Penal Code 529. A. Every person who falsely personates another in either his or her private or official capacity and in that assumed a character does any of the following, is punishable pursuant to subdivision B. So let's see if she meets any of these California statutes. 1. Becomes bail or surety for any party in any proceeding whatever before any court or officer authorized to take that bail or surety. Well, we don't have bail and her faking being somebody for bail. 2. Verifies, publishes, acknowledges, or proves in the name of another person any written instrument, which we discussed what written instrument, which is like documents, print, written form, with the intent that the same may be recorded, delivered, or used as true. Okay, so I think we found one that would apply in California to Owens. This, to me, would be what she would be possibly, allegedly, charged under 529B2. Number 3 says, does any other act whereby, if done by person falsely personated, he might in any event become liable to any suit or prosecution or to pay any sum of money or to incur any charge, forfeit, or penalty, or whereby any benefit might accrue to the party personating or to any other person. Well, I know that she might be technically benefiting if she cancels Clayton, but I'm not going to say that one's a strong one. So this says B, by a fine not exceeding $10,000 or by imprisonment of a county jail not exceeding 1 year or imprisonment pursuant to the subdivision H of section 1170 or by both that fine and imprisonment. Okay, now we have additional act. So let's see what this is. The performed an additional act is a crucial factor a prosecutor must prove to convict a defendant. Put simply, it means there must be something more than just identifying yourself as another person or showing evidence claiming you are that person. So you can't just, if she was just to say, I am Chase Jones, like just saying that you are something, it doesn't necessarily rise to the level of being able to convict or prosecute. So it says this element of the crime under Penal Code 529, false impersonation, can be satisfied if the defendant posts bail before a court under someone's name, publishes a written instrument in another's name, which is what she did when she submitted those subpoenas under Chase J. Jones. If she is in fact allegedly Chase J. Jones, her phone number seems to be attached to him for some reason. Creates a financial liability for the victim or creates a benefit for themselves. Now, I still don't know if there's financial gain there. This was brought up with Dave Neal's attorneys in things, but nothing was given, and there wasn't a suit personally to charge her or to sue her in civil court in regards to Chase J. Jones. Now, that could be something that Clayton does. Dave Neal can go in with that one just because Chase J. Jones was a member of his Patreon and was making these things trying to hurt Clayton Eckhart. Oh, look, he's a bad person. He was dancing to a song with an N-word in it. Okay, he wasn't out there calling people that. He wasn't saying it. Like, how many people if you listen to any rap song, it has that in there, unfortunately, because apparently we can't come up with creative raps anymore. Continuing on, for instance, a man is arrested for shoplifting at a store. While getting booked at the police station, he gives the police the name of his friend and then signs the forms. After he is released and fails to appear in court, police arrest his friend for an outstanding bench warrant. In this example, the man arrested for shoplifting committed an additional act when they signed the booking paperwork at the police station. So if he would have just said, my name, like she said, if Owens got arrested and she said, no, my name is Chase, that wasn't enough to go after them for false impersonation. But when she signed a document using Chase J. Jones, that was where the additional act was committed. And so, because we have an additional act, signed the paperwork, this prosecutor can prove and convict a defendant. She has allegedly committed this additional act. It is not looking good on false impersonation in Arizona or California. Could she be charged in both? Is this a multiple state thing? Or would it just be in one state? Prosecution of false impersonation. To be found guilty of violating Penal Code 529 of false impersonation law, the prosecutor must prove several factors beyond any reasonable doubt, which with discovery we could get to that. Right now, we're at reasonable doubt. Most of us are pretty sure beyond a reasonable doubt, but really in the eyes of proof, we're at reasonable doubt. To get the beyond, we are going to need more discovery and the proof of the things that we pretty much know already exist. But right now we don't have that proof beyond. We just have the reasonable doubt. These factors are frequently called the elements of the crime, are listed under CalCrim 2044, California Criminal Jury Instructions. Defendant falsely impersonated someone in their public or private capacity. Yep. That we have for sure. While falsely impersonating the defendant, committed an additional act that created a liability for the victim or some benefit for the defendant. We have that. So we have both of these elements of the crime that we think have been committed. Further, the act of falsely impersonating someone means you did so with specific intent of deceiving a person. And yeah, she did, because why else would you do this and submit this stuff to a court if it wasn't to deceive somebody? This wasn't just somebody just going out there on social media and saying all this stuff. No, this person falsified a human to falsify documents in a court of law. That is specific intent of deceiving another person. What are the penalties for a PC 529 conviction? As noted, California Penal Code 529 PC is a wobbler. And a wobbler is a crime that can be filed as a misdemeanor or a felony. The prosecution's decision on how to file this case is usually based on the circumstances of the case and the defendant's prior criminal history. If convicted, PC 529 as a misdemeanor, the punishment includes imprisonment in county jail for up to 1 year, a maximum fine of $10,000, and summary probation. That is probably where she will land, because she doesn't have a huge criminal history. And when we say criminal history, it means that she hasn't been caught and jailed for anything. She doesn't have a criminal record thus far, because you can be a criminal and never have been caught. And right now, that's what she is. If convicted, PC 529 is a felony crime that's punishment include imprisonment in county jail for up to 3 years, a fine of up to $10,000, and formal probation. A felony conviction under this statute could impact the ability to own or possess a firearm under California law. So, summary. Summary probation is informal probation, and it is supervised by the court, not the probation office. And then formal, my guess is that it is probation. Yeah, you report as directed by the probation office, and not to violate any other laws and things like that. So one, summary probation and the misdemeanor it's just followed by the court. A felony one, you have a probation officer, and it's stricter, as it should be. And then this is just the California Penal Code is a wobbler crime, which we already went over. All right, so now we talked about the false impersonation, being a false person, saying you are somebody you are not, and doing it in certain capacities. Now, let's look at the forgery part of that. So let's start with forgery with Arizona laws. Forgery and counterfeiting are crimes that have been around for a long time, but can also be committed with the help of new and developing technologies. In Arizona, a person commits forgery by falsely making, altering, or completing a written instrument with the intent to defraud, or possessing a fake written instrument when the person knows the document is fake or contains false information and intends to use it to defraud others, or presents such a fake written instrument whether it is accepted or not. So if you present these items to me, we're going to go with presenting to the court and whether the court accepts it or not. If you present this to the court and whether the court says, okay, we'll accept this into evidence, or we'll accept this filing or whatever, or they say, no, you can't submit that, the fact that you presented it. And so on this, we have falsely making, altering with the intent to defraud, possessing these fake written instruments. The person knows the document is fake or contains false information and intends to use it to defraud others, such as in these ultrasound things, and present fake written, accepted or not. It says read on to learn more about Arizona forgery and counterfeiting laws. We're not really going to go over counterfeiting. Forgery defined. A written instrument is defined as a paper, document, or other instrument that contains written or printed matter, or any token, stamp, seal, badge, trademark, graphical image, access device, or other evidence, symbol, value, right, privilege, or identification. In addition, an intent to defraud is the state of mind or intention to trick or deceive. Yeah, when you're doing this and you're submitting it to court, you have the intention to trick or deceive the judges. For example, if someone forges a celebrity signature for the purpose of entertainment, art, or commentary, they may not have the intent to defraud. On the other hand, if the same person forges a celebrity signature to sell it as an original when it is clearly not, that person would possess the intent to defraud. So like if you had a t-shirt that had like Dolly on it, and then it had like vinyl of Dolly's signature, you're selling that as just a thing. Like, you're not saying, oh yeah, Dolly signed this. I mean, obviously she didn't, and that's very well seen on the shirt. But if you were to sign a shirt that had Dolly on it, and then you had in Sharpie Dolly's signature that you forged, that, and then you tried to sell it as it was Dolly's original signature, and you went on eBay and all that whatever, and got thousands and thousands of dollars for it, then that is the intent to defraud. But I think here we have that. It's just not in the art and entertainment world. It's in the ruining people's lives category. Crimes and penalties. Forgery. If someone is convicted of forgery, they are guilty of Class 4 felony, punishable by a sentence of 1 to 3.75 years. If, however, the forgery is done in connection with the purchase, lease, all that, that's the house stuff, we don't need to go over that. Making or possessing forgery tools with the intent to commit fraud is a Class 6 felony, punishable by a jail sentence of 1 to 2 years. And making or possessing a forgery tool with the intent to use it to commit forgery is a Class 5 felony, punishable by a jail sentence of 2 to 2.5 years. So that's some serious stuff. Like, this doesn't give misdemeanor anywhere. Forgery is no joke. But yet we have tons of it with Owens, allegedly. All right, so let's look at California, where the stuff was submitted. I don't think it was created in California, but it was submitted in the California courts. I think most of it has to do with Arizona, but because she submitted a forged document or two to California, California laws might apply. So let's see. Penal Code 470C. Every person who, with the intent to defraud, alters or corrupts or falsifies any record or any will, codicil, conveyance, or other instrument, the record of which is by law, evidence, or any record of judgment of a court, or the return of any officer to any process of any court, is a guilty forgery. So, falsifies a record with the intent to defraud, evidence, I think, we've got court, is guilty of forgery. Penal Code 470D. Every person who, with the intent to defraud, falsely makes, alters, forges, or counterfeits, utters, publishes, passes, or attempts to offers to pass as true and genuine any of the following items, knowing the same to be false, altered, forged, or counterfeited, is guilty of forgery. If you know these items to be false and you are trying to pass them as true and genuine, according to Penal Code 470D, you are guilty of forgery under the laws of California. This is not great. We know this. And all of us sit here and wonder, will charges ever come around? Don't know. But there are laws that she has broken that could push people. If somebody wants to do that because she has done it and it is proven, and if we have a judge saying things, it could get pushed for that. Somebody may have to press charges in order for it to happen, and the people might not prosecute her just to prosecute her. Somebody's going to have to make a movement to it, whether it be Clayton or maybe Dave Neal. But this is ridiculous. Now in California, it does look like it is a wobbler charge. There can be misdemeanor forgery and felony forgery. Probably in Arizona there is too. It's probably similar, but just from where I found the stuff, it just showed felony convictions. Misdemeanor penalties. Misdemeanor forgery in California can lead to various penalties, including fines and potential jail time. A conviction for a misdemeanor forgery may result in a sentence of up to 1 year in county jail. The court can also impose fines up to $1,000 for each offense. We know there are two, at least, that went to the California courts with each of those documents of a subpoena. That may not be considered forgery. It may just be considered false impersonation, but you're lying on these documents and you're signing people's names. So could it be both? So that's $2,000 there just on those two, if those are considered forgery. Don't know if they are. Factors such as value of the forged item or document can influence the severity of the misdemeanor forgery penalties. For example, forging a check for a small amount may result in lower fines and a shorter jail term compared to forging a high-value document in court. What is considered a high-value document in court? You didn't write a big check, but you submitted fake documents to a court. And you've done it multiple times in Arizona. You did it in California as well. Even in the Maraschini case, we could go there. So, like, Arizona and California has a lot of room with false impersonation and forgery documents being submitted to the court with the purpose to deceit another individual. Felony convictions, consequences. When it comes to felony forgery convictions, the consequences are more severe, obviously. Individuals convicted of a felony forgery may face imprisonment in state prison, not in the county jail, state prison, for a significant period, often ranging from 16 months to 3 years. In addition to prison time, fines can be substantially higher than those for misdemeanor offenses. The repercussions of felony forgery convictions extend beyond incarceration and financial penalties. Convicted individuals may also experience challenges in securing future employment, obtaining professional license, or accessing certain benefits due to their criminal record over time. So, could that take away these real estate licenses that she has? Or whatever these other licenses that she just got a new one not that long ago. Those could all be possibly taken away if she is convicted on a felony for these things. So there we have it. Arizona and California laws on false imprisonment, or false impersonation, not imprisonment, false impersonation and forgery. Will any of these happen for Owens? Who knows? Should some of them? I think they should, because she has affected at least 4 men's lives. And she has shown a pattern of doing so. It wasn't a once, oops, did it. It has been in every single case that we know of. Other than Matt's. We don't know enough about his case to know if there was fraudulent stuff. We haven't seen anything from that particular case. But there is forgery in the Maraschini, Gillespie, and Eckerd case. There is false impersonation in the Eckerd and Dave Neal suits. What could this mean? And do you think any of it will happen? That is what I want to leave you with today. Let me know your thoughts in the comments, of course. If you have anything to add or correct, feel free to. Our quote of the day is, "Fear follows crime and its punishment." Because when you are committing these crimes and doing these things, you're pretending to be somebody you're not. You're doing your arts and crafts and submitting these things to courts and lawyers. You're not fearful in that time, because if you were, you wouldn't be doing it. Now, are you fearful after you commit the crime? Absolutely. Are you going to be caught? And then fear really, really sets in once you have been caught. And you are left not knowing what punishment or consequences are coming up for the crime that you committed. The unknowing. The fear of getting caught. The fear of, is it just going to be a fine? Is it going to be a misdemeanor? Is it going to be a felony? Am I going to go to county jail? Am I going to go to prison? Fear follows crime and its punishment. That is it for me. I'm the Loud Little Ducky. Please hit that like button, share this video, subscribe, and turn those notification bells on for more videos in the future. Bye!